Thank you for joining us today for a half-hour webinar on responding to child safety disclosures, complaints and allegations. I would like to start by acknowledging the Wurundjeri Woi-wurrung people of the Kulin Nation, traditional custodians of the land on which I am presenting today, and pay my respect to their elders past and present. Some of the content we will be discussing today can be quite confronting and distressing, as we will be talking about allegations of child abuse and harm. Should you at any time feel the need to take a break, please do, And we have also listed some external organisations up on the screen if you feel triggered by any of the content. My name is Patrice Fitzgerald, and I am the Principal Lawyer and Director at Safe Space Legal. Safe Space Legal is the first law firm in Australia to practice exclusively in all aspects of child safety and safeguarding. I have practiced as a lawyer for about 18 years, primarily in safeguarding, child protection, institutional abuse and family violence. And I have witnessed firsthand the trauma that children and survivors have experienced when they have been abused and also been further harmed by the organisation's responses to their concerns. I am also joined by Brett Hogan, who is a Senior Associate at Safe Space Legal. Brett has more than 35 years' experience working with children and young people and people with disabilities. In addition to his legal qualification, he holds a Bachelor of Social Welfare and qualifications in disability. I also introduce our practice manager, Ollie Corrigan, who is often the first point of contact when you want to get in touch with Safe Space Legal. At Safe Space Legal, we are often contacted when a critical incident has taken place. And for those who have been involved in a critical incident, whether it is in receiving a disclosure, needing to make a report, oversee an investigation, or manage staff after an incident, we know how incredibly stressful this can be for all those involved. Today's half-hour webinar is suited to organisations who work with children and young people across a variety of sectors, and for those individuals who work with those organisations. We will be providing a high-level overview of what organisations need to consider prior to an allegation being made, legal reporting obligations, best practice when responding to a child who has made a disclosure, and the conduct of child safety investigations. Due to time limitations today, we will not have time to answer questions within the webinar, but we welcome you to put any questions you have in the chat or send us an email, and we will respond as soon as we can. Safe Space Legal's motto, prevent, comply, respond, encompasses the three important elements we say organisations must consider in order to promote a child's safety and safeguard children and young people from exposure against harm. Children and young people are inherently vulnerable due to their age, development, and power imbalances which exist within organisations. They have the right to feel safe, supported, and secure in their homes, the community, and within organisations that have the care, supervision, and authority of them. Child safety is everyone's responsibility, and every person has a role to play to ensure that children and young people are protected from maltreatment and abuse. Organisations working with children have legal and moral obligations to protect the children they are working with from harm. Safeguarding is the process of an organisation taking steps to promote the well-being, safety and welfare of children and vulnerable people and protect them from the risk of harm, trauma and abuse. The first element of the Safe Space Legal safeguarding cycle is prevent. Organisations have multiple legal and moral obligations to prevent children and young people from being exposed to maltreatment. Organisations must take steps to prevent children from being exposed to harm before it occurs. The second element of the safeguarding cycle is comply. Organisations are required to have a thorough understanding of and comply with their legal obligations, which we will discuss in greater detail shortly. The final element of the safeguarding cycle is respond. And what we're looking at today is how organisations should exercise best practice in responding to child safety disclosures, complaints and allegations. Organisations have a responsibility to respond to allegations of abuse in a child-focused manner, utilising processes which are consistent, transparent and timely, and ensure investigations are trauma-informed and thorough. Organisations should have clear and accessible complaints handling processes in place, which are child-focused and trauma-informed, clear reporting lines for complaints and incidents, which is followed consistently across the organisation, an understanding and processes of reportable conduct requirements if they are applicable, and ensuring that obligations under reportable conduct schemes are properly adhered to, making external reports and information sharing to other regulators, including the police, ensuring investigations are conducted by trained professionals with experience in trauma-informed interviewing and the legal requirements which accompany investigations, and conducting reviews following any critical incident to develop an understanding of any systemic issues which have led them to the harm and mitigate further risk. What I hope you gain from today's webinar is that in order for an institution to provide a best practice response to a disclosure of a complaint or an allegation, all elements of the safeguarding cycle must be met. The cycle is a continuum, and so an organisation and individuals working within the organisation should ensure that they are considering all elements of the cycle, and then after any critical incident, they should go back to considering further preventative steps. Many organisations and individuals that I speak to, find that the obligations placed on them are quite onerous, and I couldn't agree more, but there's a really good reason for this. We are well aware of the abhorrent history of institutional abuse in Australia, which has led to many independent inquiries, including the Royal Commission into institutional responses to child sexual abuse. The Commission's final report was issued on the 15th of December 2017, and the purpose of the Royal Commission was to inquire about how organisations responded to allegations of child sexual abuse following the repeated failings of institutions within Australia. The Royal Commission ultimately took 42,041 phone calls, reviewed 25,964 emails and letters, held 8,013 private sessions and 57 public hearings, and referred 2,575 matters to police. Although the Royal Commission was focused on child sexual abuse, the Royal Commission found that 48.5% of the survivors also experienced other forms of abuse and maltreatment. The Royal Commission stated in its final report, "It is now apparent that across many decades, many of society's institutions failed our children." Why am I telling you all these stats and findings after 5.5 years since the final report was issued? Because we need to remember why these obligations exist and where they come from. The stories from the Royal Commission should not be forgotten, as they have led to major systemic change across Australia, with some states still evolving. And this is vital in reducing the risk of harm to children and young people. Fast forward now to last year in 2023, the Australian Child Maltreatment Study released its findings on the 3rd of April. The ACMS is the largest study of child maltreatment and neglect conducted in the world. 8,503 people aged between 16 and 65 years participated in the study, and the research focused on the long-term impact of child abuse on participants. The ACMS states that the findings are deeply sobering. Child maltreatment is widespread in Australia and associated with early and persistent harm. In a brief snapshot, the ACMS found that 39.6% of people interviewed were exposed to family violence, 32% experienced physical abuse, 30.9% experienced emotional abuse, 28.5% experienced sexual abuse, and 8.9% of people experienced neglect. Multiple factors made some children more vulnerable to abuse, and people who had experienced abuse and neglect were 2.8 times more likely to experience adverse mental health outcomes. For more information about the Royal Commission and the ACMS, we will put a link in the chat to the full reports. Child safety is everyone's responsibility, and as individuals and organisations working directly with children, you are in a position to ensure that disclosures, complaints, and allegations are properly responded and reported. Each state within Australia has different legislation in relation to child safety. We will be providing a high-level review of the different state-based obligations, but note that these obligations we are talking about today are not exhaustive. Depending on the sector you work in, there may be other obligations or regulators which you are also required to comply with. It is absolutely vital that organisations and individuals working within organisations are aware of their legal obligations and ensure they are compliant before a critical incident occurs. When a disclosure, complaint, or allegation is made, it is often highly stressful and emotive, and if legal obligations and processes are not properly followed, it can have detrimental effects on the outcome and may impact upon the trauma experienced by the complainant, witnesses, staff members, and others involved. Also, individuals who fail to comply with their obligations may be held personally liable. Therefore, it is best practice to ensure that you and your staff are clearly aware of what obligations exist and how the organisation responds prior to an incident occurring. One of the major recommendations which arose out of the Royal Commission is the recommendation that organisations comply with the nationally consistent 10 child safe standards. These recommended standards from the Royal Commission became the national principles for child safe organisations and have been endorsed by all states and territories within Australia. Some states have legislated the national principles, and they may be known as child safe standards or the child and youth safe standards in Tasmania. And some states are continuing to evolve, We actually expect that some states will also legislate the national principles in the near future. The national principles set out minimum standards for ensuring that organisations are child safe. National Principle 6, which is Child Safe Standard 6 and Child Safe Standard 7 in Victoria, states that an organisation must ensure that processes to respond to complaints must be child-focused, and institutions should have a clear, accessible and child-focused complaint handling policy and procedures that set out how the institution should respond to complaints of abuse and harm. Another major recommendation arising out of the Royal Commission is the implementation of a reportable conduct scheme. In Australia, 4 states and 1 territory have implemented the reportable conduct scheme, which is overseen by a state-based independent regulator. Each of the reportable conduct schemes are similar in nature, however, they do differ slightly in relation to the terminology and obligations on the head of the organisation. A head of an organisation under a reportable conduct scheme is ultimately required to comply with the scheme and must ensure they have systems in place to prevent child abuse and to respond to allegations of abuse. The head of entity must ensure that the allegation is notified to the regulator within the prescribed time period and ensure that the allegation is properly investigated and findings are made pursuant to the scheme and reported back to the regulator. The outcome of a reportable conduct scheme investigation may result in other government regulators assessing the suitability of a person to work with children and may be the basis for the employer to take disciplinary action. If you are an organisation who works with children and young people in Victoria, New South Wales, the ACT or Western Australia, you must be aware of what is required under the reportable conduct scheme in the respective states and make sure you comply with the obligations. I should also note that from the 1st of January 2024, Tasmania also implemented a reportable conduct scheme. There are also many other obligations which exist when a disclosure, complaint or allegation is made or when a child is risk at harm. We do not have time to dive deeply into each of the state-based obligations, but we have provided a snapshot up on the screen. Please be aware, as I said before, that if you're a national organisation, you may have differing obligations in different states. This is not an exhaustive list of obligations and depending on the sector that you work in. We have already covered off on the reportable conduct scheme and national principles. Other obligations which may exist in your state are mandatory reporting obligations. As you'll see from the snapshot, mandatory reporting exists in all states, but those who are required to report state to state may differ. There are also other types of criminal offences for failing to disclose, respond or protect a child who is at risk of abuse. Once again, these criminal offences differ across each state. However, they make individuals responsible for failing to report or protect children who are at risk of abuse. I strongly urge all organisations and individuals working with children to be aware of their legal obligations before a concern is raised. Staff must also be aware of any organisational child safety policies, procedures and codes of conduct which are in place to ensure of their obligations when responding to concerns from an organisational perspective. What we know from the Royal Commission and anecdotally from all the work we have done at Safe Space Legal is that organisations who have had to manage critical incidents, it's the way in which the critical incident is managed, where the process is properly followed, it's trauma-informed and child-focused. It can have a profound effect on the alleged victim and others associated with the incident. When an organisation prioritises child safety and complaints are taken seriously and responded to promptly and thoroughly, a culture of child safety is embedded within the organisation, and the organisation's reputation is less likely to be damaged. I have provided a background into why and what obligations exist when a disclosure, complaint or allegation is made. And I'm now going to pass over to my colleague, Brett, who will talk more about the practical side of when a critical incident occurs. Thank you, Brett.
Land today and pay my respects to elders past and present. It can be extremely difficult for children to speak about the things they've experienced or to know how to put things into words if they do not have the language to express what they've experienced or have not yet processed their experiences. It's important when speaking with children and young people that a safe space is created for them to speak openly and honestly about their experiences and that we use a trauma-informed technique to support children and young people. But remember, you're not expected to investigate a child safety allegation. That will happen later. If you are speaking with a child and they are forthcoming with information and want to tell you something, that's okay. However, you should not start interviewing a child. If you do feel like a child is opening up to you, it's okay to ask open-ended questions. Is there anything else you want to tell me? What happened next? Can you explain what you mean by that? However, interviewing and speaking to a child is a skill. If an allegation ends up being reported to police, the initial questioning of a child can be detrimental to later investigations. A trauma-informed response is a method of engaging with a person who's experienced a traumatic event or series of traumatic events. When utilising this method of engagement, the purpose is to create a safe space for a person to speak without re-traumatising them by building rapport and creating a supportive environment to promote healing. It's important to understand that children and young people may disclose abuse at any time. If the abuse is ongoing over a period of weeks, months, or even years, they may disclose whilst the abuse is happening, whereas others might disclose immediately after the abuse has ended or even later. The Royal Commission found that on average, it took a survivor over 23 years to disclose abuse. Barriers to disclosure may include a range of factors. We found that the most common reason a survivor has given for not disclosing abuse is that I thought I wouldn't be believed. However, other factors may be that a child is concerned about pressure or threats from a perpetrator, relationship to the perpetrator, pressure from the child's family, which may particularly be a factor in some culturally diverse families, feelings of embarrassment, shame, or self-blame. Male victims might hold fears of stigmatization, including being labelled a victim or a homosexual. The timing of the disclosure, the age of the child or young person, will impact on what is considered an appropriate response. The other things to keep in mind that children vary in their way in which they disclose abuse. Depending on their developmental level and a child's language skills, the disclosure may be quite clear or it may be less clear. A child may make a full disclosure in one sitting, or they may slowly disclose over time. So in speaking with children, we should create a space where they feel comfortable speaking or arrange to meet with them where they feel safe and with someone they trust, such as a parent or a teacher, if appropriate. Create a casual and comfortable environment by building rapport. Allow the child to tell their story in their own words and with minimal interruptions. Show that you are listening and respecting their story. Only ask the child open-ended questions so they can create a narrative. Asking closed questions can be leading and can also shut down a conversation because it elicits yes/no responses. Be mindful of non-verbal cues such as facial expressions and body language. Validate that what they've went through must have been difficult. Thank them for taking the time to speak openly about something that is difficult. Reassure a child that they have safe people they can speak to if they want to talk more about the incident later on. Ensure that once a child makes a disclosure, you comply with your legal obligations to report, and also your organisation's policies with respect to reporting. And ensure you keep thorough records of the disclosure, reports, actions, and any decisions taken. We've gone through a high-level review of the legal obligations which exist across Australia. Now we're going to talk about what steps need to be taken when a disclosure, complaint, or allegation is made, and you as an individual or acting on behalf of an organisation are required to take action. Step 1, if the incident is an emergency, you must call 000. Step 2, ensure that the child or the survivor is safe and take steps to remove any physical risks and provide them with support so that they feel safe and know that action will be taken to keep them safe. Step 3. Preserve any evidence which exists in relation to the concern. This may be physical evidence such as clothes, phones, or other types of physical evidence, or it may be documentary evidence such as incident reports, notes of meetings, records of disclosures, photographs, just to name a few. Remember that this evidence may be required to be handed to other authorities, such as the police or child protection. So ensure that you follow any instructions given by the agency in relation to the evidence. Step 4. Ensure you're aware of your legal obligations to report. As we previously stated, depending on what state you live in will depend on what reporting obligations exist. Make sure you keep thorough records of all reports or decisions made about allegations. Step 5. If a reportable conduct scheme exists in your state and the allegation is reportable, ensure you follow through your reporting procedures in relation to the reportable conduct scheme. Depending on your role in the organisation, this may differ. The head of entity is required to comply with the scheme, but as an individual, you must follow your processes to ensure that the head of entity or other role is aware of the concern so that the reportable conduct scheme can be complied with. Step 6. Be aware of your obligations under the organisation's child safety policies and procedures in addition to your legal obligations. Generally, all staff will be required to comply with a suite of child safety policies and procedures. If in doubt, ask a manager for support in accessing these documents. Read them and make sure you understand them before an incident occurs. Step 7. Once you have fulfilled all your legal reporting obligations and police or other regulator has provided clearance to commence the investigation, you can then appoint an investigator and commence the investigation. Whether a reportable conduct scheme exists in your state or territory or not, your organisation may be required to conduct a child safety investigation, depending on the allegation. Historically, organisations would often conduct investigations internally, and we now know from the Royal Commission how problematic this can be, especially depending on the seriousness and complexity of the allegation. The Royal Commission recommended that wherever possible, investigations be conducted by an external, independent investigator with the skill and expertise that's required by legislation under a reportable conduct scheme, which exists in each state. When considering whether to appoint an external independent investigator or conduct the investigation internally, we suggest you think about some of the following considerations. Can the organisation identify anyone within the organisation to conduct the investigation? There may be a conflict of interest. The investigation might not be completed in a reasonable time frame internally, or the investigation is complex and beyond the skills, capabilities, or experience of an internal employee. If the reputation of the organisation is at risk, consider the appointment of an external investigator so that those involved in the investigation feel that the investigation will be conducted independently and properly. Whether or not the investigation is conducted internally or externally, reasonable efforts should be made to gather relevant evidence for an investigation. Organisations should be compliant and providing all available evidence to an investigator so a balanced and thorough investigation can be completed. Evidence should be relevant, reliable, and probative so the investigator can establish whether the reportable allegations amount to reportable conduct. Evidence can include physical evidence such as documents, photos, emails, and videos, site inspections or floor plans, direct evidence from the alleged victim, witnesses, the subject of the allegations, or the parents of the alleged victim about what they saw, heard, or did, and expert evidence from specialists such as doctors, psychologists, or computer experts. The subject of the allegation is entitled to procedural fairness. The procedures undertaken in an investigation should be fair and reasonable. To be fair, the subject of allegations should be provided a detailed letter of allegations prior to any interview, including the scope of the allegation. They should be allowed to have a support person present for an interview. They should be provided a reasonable opportunity to respond and give their side of the story. They should be made aware of the consequences if adverse findings are made against them. And you must ensure that the responses are genuinely considered by the investigator, organisation, and head of entity before a final decision is made. At the conclusion of an investigation, a report must be prepared. The information contained in the report must allow the reader to understand how the investigation has been conducted and that the investigator has made fair findings based on the evidence. Each allegation should be clearly and separately identified and particularised. The report should set out the approach adopted by the investigator, the evidence obtained, a summary of the evidence, an assessment of the evidence, and the importance the investigator gave to each piece of evidence and why. The report must set out the findings of fact, whether the allegations are proved or disproved, and what evidence has been relied upon to reach a conclusion. The report must also set out the recommendations about the findings that should be made. The decision maker must agree with the conclusion reached by the investigator before adopting them. However, the decision maker should not depart from the findings or recommendations unless there is a good reason to do so based on the evidence. Note that a recent Fair Work Commission judgment found an organisation had adopted an investigator's finding without a proper consideration of the finding themselves. We can provide a link to that judgment if anyone's interested. We understand that there may be times when an investigation may be conducted internally. This may be in a situation where an organisation has its own internal investigation department, or where financially the organisation does not have the budget to appoint an external investigator. You'll need to preserve and consider all relevant documentary evidence. You'll need to identify relevant witnesses. You'll need to contact witnesses and potentially parents of children and be sensitive as to what information is provided, balanced against the risk of influencing witness evidence before the interviews have been conducted. There must be procedural fairness for the subject of the allegations, as already discussed. Requesting information from other sources or agencies, consider what power do you have and what barriers there may be to sharing information. You need to ensure that in drafting the investigation report, it properly sets out the evidence and can demonstrate how many findings and recommendations were reached. When considering historical allegations, as mentioned, on average it takes 23.7 years for a survivor to report. Therefore, these can be challenging to investigate. You'll also need to consider whether historical allegation is reportable under a reportable conduct scheme, if one exists in your state. Considerations for future litigation. At any time after an investigation is concluded, a victim may litigate in the civil jurisdiction or report the matter to police for a criminal investigation to occur. There is no statutory limitation period on allegations of sexual abuse, and there is a current freeze on document retention in relation to child wellbeing records. Organisations should be aware of their legal obligations when documenting reportable allegations and ensure they maintain proper records. An investigator should also document all information and evidence and clearly record their processes and methods. It is important to ensure that all original documents and evidence collected throughout the investigation are stored securely and in its original condition, and in the event that any future litigation arises. Organisations should also be aware of who has access to the investigation report and records, as it may be that at a later date, police determine to investigate and charge, and it is important that any information obtained in a reportable conduct scheme investigation has not been released. Root cause analysis and review of policies. Once an investigation is finalised, it's essential that organisations then consider any systemic concerns so that the risk of the child affected or other children is mitigated. Consideration may need to be given to what risk factors can be identified by virtue of the allegation or concern raised. How can the organisation take steps to mitigate that risk? Should policies or procedures be amended or implemented to mitigate the risk in the future? And back to you, Patrice.
Thank you, Brett. At Safe Space Legal, we offer a full range of safeguarding services to support organisations across Australia to be best practice leaders in child safety. Our services encompass all three elements of the safeguarding cycle, and we work closely with our organisations to tailor our services, including child safety investigation, training, audits and gap analysis, advice, drafting policies and procedures, and conducting root cause analyses of critical incidents. We hope you have enjoyed the session today, and I hope it's provided a snapshot into what is required from a legal perspective and from a practice perspective when a disclosure, complaint or allegation is made. We welcome you to contact us if you have any further questions. Unfortunately, we did have some technical problems today, but we welcome you to contact us if you'd like any of those links that we suggested, or if you'd like to get in touch for any support. Thank you for your time.